Hello and welcome to Lawyer to Lawyer on the Legal Talk Network.
Today we are talking about the Trial Lawyer Hall of Fame, which opened its doors at Temple University's Beasley School of Law in Philadelphia. This institute recognizes and honors individuals, past and present, who have fought on behalf of citizens in the name of justice. To quote from the site, "The men and women have left an indelible mark on the American legal tradition through a lifetime of service to the American public, the Constitution, and the American trial bar." We've got joining us from his studio in Texas, Trial Lawyer Hall of Fame inductee Howard Nations. Among his many awards, he is the recipient of the W. McKinley Smiley Jr. Lighthouse Award, the Belleye Society's Mel Award, and the MTMP's Clarence Darrow Award. Welcome, Mr. Nations.
Well, good afternoon. Thanks. Glad to join you.
Who do you think is the best trial attorney you've ever known?
Well, that's a very easy question for me because the answer is Percy Foreman. When I was a law student at Vanderbilt, Percy came up and did a demonstration, and he gave a speech for 1 hour, and I'll tell you that was the most important single hour of my legal education. When I came to Houston, Percy actually became my mentor. I watched him in court. He showed the power of nonverbal communication, and he taught me the importance of the law, knowing the law, the importance of hands-on preparation by the attorney doing the work, and the very big importance of attention to detail. Percy said, when I walk into a courtroom, I know more about the law of that case than anybody on the planet. And when I walk into a courtroom, I know more about the facts of my case than anybody on the planet. Tremendous, tremendous trial lawyer.
Having heard both of you, or two of you rather, cite defense lawyers as the greatest trial lawyer you knew, it makes me wonder whether, from where you sit, there is a difference between a plaintiff's trial lawyer and a defense trial lawyer, or a civil trial lawyer and a criminal trial lawyer. Howard, what do you say about that?
Well, there's some fundamentally basic skills that every type of trial lawyer has to possess and has to be able to express in front of a jury. The ability to communicate effectively with the jury, the ability to read people, the ability to pick a jury, the ability to know as you're going through a trial how your story is resonating with the jury, how are you being received. There's also commonality in whether you're doing civil cases or criminal cases. You have to know the law. The law is a starting point, and you have to really do what we do, you actually have to love the law. And regardless of which side of the docket you're on, there should be a very strong interest in doing justice in a case. If we go in attempting to do justice in a case and knowing what justice is and thinking in terms of a just result for our client, if you've got clients on both sides trying to reach a just result, then you get an honest trial to a jury. And I'm a strong believer in the jury system and in the integrity of juries. And they do find a way. Every time I've ever lost a case, you think, boy, the jury just completely missed that. But then when I go back and reflect on it, or when we go back and talk to jurors later, you find out, no, you know what? They're right. I'm the one that missed that. I did something wrong. I failed, or I just didn't have the facts on my side. But the jury system works. So as a great trial lawyer, you have to be able to communicate with them, you have to be able to read them, and you have to be able to deliver a message to them that carries the theme of justice for your client.
One of the areas where plaintiffs' lawyers do get criticized, or one of the criticisms you hear about plaintiffs' lawyers relates to the whole contingency fee structure. And there are some who will say that contingency fees are sometimes windfalls for lawyers, especially in big dollar cases or in class actions where members of a class might get a relatively small recovery individually. Howard Nations, I'm wondering what your thoughts on that. What's the reason for the contingency fee? How do you defend the contingency fee?
Well, it's very simple to defend. The contingency fee is the key to the courthouse for people who cannot afford to hire a lawyer. who don't have the money of the corporations, who don't have the money of the insurance companies, who can't afford to go into court and pay a lawyer on an hourly basis. The people who are the injured, they're often severely crippled. Their family life is destroyed. Their financial life is destroyed by the actions of defendants, and they're quite often can't pay their medical bills. They have no income for supporting families. How are those people supposed to find a way into the courthouse if they also had to pay a lawyer by the hour to represent them? The answer is they wouldn't. And that's the reason for the attack on the contingent fee. The attack on the contingent fee is made by the tortfeasors of America, who are the ones who don't want the injured parties to have a fair shake, to have their day in court. I went into a case in which a 3-year-old child was brain damaged. His parents were both injured in the case. They had no money. The father lost his source of income. Everybody lost their source of income. The child was severely brain injured, and it was all because of an event that happened up on a highway in West Virginia with a truck driver. But then we had to, in addition to him, we had to take on the manufacturer of the product. The child was brain injured by virtue of a child safety seat, supposedly called a child safety seat. We took on that manufacturer. We took on that 18-wheeler driver, and I spent. I don't usually talk about what I spent, but this is what this question's about. I spent well over $400,000 in that case, risking out of my own pocket. I expended untold amounts of time. The people I had to pay to handle that case, all the people who on my staff, all the money, time, effort, and energy we put into that, they did not pay us one penny in that case. We were able to handle that case for them. We took all the risk of being able to win. We took all the risk of being able to prove to a jury that that car seat was defectively designed, a car seat that was being used all over the country, that it was defectively designed, and that was a cause of this brain injury to the child. And we were successful in doing so. And as a result of that, the child is receiving lifetime care. The parents receive the money they need to put their life back together. And so when the child reaches age 18, he'll start getting his additional funds in trust for the rest of his life. So it's a huge change in the life of that family. And most importantly, that car seat, as part of the ultimate settlement of the case, the car seat was taken off of the market by agreement with the manufacturer, because that was a term of the settlement post-trial. So we do that. We did it on a contingent fee basis. If I had lost that case, I would have lost $400,000. But more importantly, if I had lost that case, that 3-year-old child would never have gotten the medical care he needed, and those parents would have been absolutely broke and their family destroyed forever.
Well, it looks like we're just about out of time for this segment. We want to thank our guests, Mr. Papantonio, Mr. Nations, and Mr. Girardi, for joining us today.